This video covers probate or trust property and risk of foreclosure. And we're going to deal with California foreclosures as they relate to foreclosure laws in this state. As an overview, some important points to know. The timeline can actually be shorter for a property that's in foreclosure where the borrower was deceased and now there's an active probate, or even before they've opened up a probate. And that probate does not automatically stop the foreclosure. That's something that some people assume, but it's not true. Most foreclosures can be cured by paying the back payments and fees. Most people know that. However, with reverse mortgages, they cannot be cured and must be paid off in full because the loan has become a balloon payment. Some foreclosures are due to a breach of other terms of the loan. For example, if the property has severe neglect, code enforcement has got involved with your local city, agency, or other problems that the lender has called the loan. So what solutions are available? Well, we're going to look at these solutions: borrowing, selling, modifying the loan, or forbearance agreements. We'll look at some hybrid plans, which are combinations of both, and fresh start options. Borrowing is typically solved by getting an equity-based loan. It needs to be an open probate or a trust. The borrower is the personal representative, and they may or may not be an heir or beneficiary, but they are the executor or administrator, a special administrator, or trustee or successor trustee of it if it's a trust. You need enough time to process it through the court if it's going to be a probate, and it will probably be requiring a court order, and so we have to allow enough time for that. Now, if you want to see the probate fiduciary loan video for more details, you can see more particular what's necessary if we go the borrowing route as far as getting a new mortgage. Selling requires enough time to find a buyer and to close escrow. And if you are facing a foreclosure in your probate and it's 24 hours before the trustee sale, that probably isn't going to work, especially if you haven't opened up probate either. Many buyers won't perform as promised, and that's something that we need to be really concerned with. And they may be scared off by the fact that it's a probate or a trust and that there's extra complications involved. Better is to have a cash buyer who's sophisticated enough to understand what's necessary when buying a property in probate. Certainly, beware of agents and door knockers making promises. And 30 plus years of being in this business, that's become a very big problem nowadays. So for more details on how to sell your property and get cash for your probate real estate, look at the video we have and you can start the process there right away. If you want to modify the loan, you need to remember that you were not the borrower, and so it may not be as easy as if you were the one who actually signed for the loan. But you could start by talking to the foreclosure company who's handling the foreclosure legal action. They may refer you to the loan servicer, and ultimately you'll probably want to talk to the lender's loss mitigation department. That's usually their legal department. They may have staff attorneys or paralegals or other people who work for the lender who deal with problems just like yours. You can always ask for the lender's asset manager as well. You can ask for a note payment or principal reduction, just remembering they may not be as open to working with you unless they can see it's an open probate, and remembering that you were not the actual signing person on that loan. A forbearance is possible with the loan servicer. Sometimes the lender will work at this, but it's an agreement to cure the back payments, and where you may want to double up the payments or something. There's no rigid rules to forbearance agreements, but you can expect at minimum they're going to require some kind of a good faith deposit from you or the borrower, and you're going to have to expect double payments or more, most likely, maybe even in addition to your regular payments to get it current. Forbearance, like loan modifications, lenders are not as likely to work with a borrower who is actually not the person who's signing the loan when it's an open probate estate or trust, but it is possible. Hybrid solutions are typically not offered by lenders. They're usually offered by a third party. An example would be a sale and leaseback, where this third party offers to bring the loan or loans current in addition for some benefit that they're going to get later on, where they perhaps offer to sale or lease the property to you or to the estate, offer a life estate, or you mutually agree to sell the property later and have some kind of an agreement to split the proceeds of the equity. You'll need to be able to balance the benefits for both. Now, fresh start options are designed to get you back on track without having to borrow more money. It's not a loan, so you don't have to pay it back. You can keep the money, but it's going to be applied to the back payments and whatever necessary to bring that loan current. Use the money to cure the defaulted loan, insurance, perhaps up to $1,000 cash for personal use for the estate. But what's going to be asked in return is that we're first in line to buy your house should it ever be sold at a later date for the terms we would set today. So who can qualify for any of these programs? Well, typically someone's going to be need to be the administrator of a probate estate, whether there's a will or no will. Probably want to have a copy of a death certificate as well. They could be the executor, or they could be the special administrator. Trustees and co-trustees of trusts, conservators and guardians, and private fiduciaries and public administrators, and of course the owner of record title. Consider the foreclosures are already problematic. They're further complicated by the death of a borrower. By all means, remember that makes it just that much more difficult, and that very few lenders really understand probate. Attorneys and judges have limitations too, so don't expect them to be able to provide miracles. And don't expect simple answers to complicated problems, because these can be very involved. Remember, the longer you wait, the fewer choices you'll have to select from, if any. So how do you get started? Well, you'll be clicking on the Get Started button, submit the online questionnaire, we'll review your documents and set up a phone consultation, and we'll determine the value by doing an appraisal, and then together we'll determine the best possible plan. So help us help you. It saves time, no obligation, no personal information is asked for the online questionnaire. And this is going to include information about how you found us, information about the borrower, if you're not the borrower, if you're, for example, the attorney or staff, some information about the property and the existing loans, particularly the loans that are in foreclosure, any liens, and the legal information about the attorney and the case, and other support information. Our typical clients are professional fiduciaries, public administrator, moms and dads, sons and daughters, grandkids, aunts and uncles, and anybody who needs to borrow on an estate property or resolve any kind of a foreclosure matter. We've been doing this for many years. We want to help you resolve your probate foreclosure too.